we're going to give you a warning letter. You say, that's nonsense, I didn't do this, that's garbage, and get angry, and they turn around and say, fine, then we're going to terminate you, which I've had happen many, many times. That is not okay. You can't just up the discipline because you feel like it, right? Whatever you said the discipline was going to be, that's what the discipline is.
The facts, dates, and events presented in this video are from the member's best recollection and may not be fully accurate. This video is intended for entertainment purposes only. Always consult with your local union about your rights and duties at your workplace. The opinions shared on this video are our own and do not necessarily represent my employer's positions, strategies, or opinions. All views shared are protected under the National Labor Relations Act.
What is going on, everybody? So today I have Greg Kerwood out of Local 25 in Boston, and we are going to be covering the 7 tests of just cause. We've never covered this on the channel before, but I think it's important that everybody knows these things. And so we're just kind of going to get right into it. Now, the 7 tests of just cause are actually not in your contract. And if anything, it's very vaguely referred to in the contract, and I'm just going to go off of my discharge language under the Southern Supplement. But it just states the employer shall not discharge nor suspend any employee without just cause. And that is referring to the 7 tests of just cause. So, Greg, I'm going to ask you first. Now, the 7 tests of just cause are not in the contract. Why are they relevant? Why are they a thing?
So the 7 tests of just cause were developed by an arbitrator, I believe, back in the early 60s, but don't quote me on that, because this just cause language gets used all the time, and he was unhappy with the way arbitrators were sort of randomly deciding what was just cause and what wasn't. So he established his own set of rules. Those were sort of adopted by other arbitrators unofficially, to determine whether discipline was just and fair. So they're really, if you take them as a whole, it's sort of just a common sense layout of fair behavior and fair use of rules and discipline, so that people are treated equally across the board and have an opportunity to correct any behavior or own up to mistakes or whatever, without the company just throwing them out for random reasons.
With that being said, let's get into the 7 tests of just cause, by the first one being fair notice.
So fair notice says an employer may not discipline an employee for violating a rule or standard whose nature and penalties have not been made known. So in other words, they can't just make up a rule on the spot or have a rule hidden in the back of their desk drawer and pull out the company book and say, look, there's a rule, you broke it. You have to be made aware of the rules. Everybody has to be made aware of the rules. And in addition, has to be aware that there will be discipline or punishment for those rules. So you can't just have a sign saying no, whatever, without people understanding that there will be consequences for violating those rules. So that's important because, it makes sure that everyone knows what the rules are ahead of time and helps to demonstrate if you did break the rule, you knew you were breaking a rule when you did it, and therefore discipline would be justified.
All right, the second one, prior enforcement. What is that?
Prior enforcement says an employee may not be penalized for violating a rule or standard that the employer has failed to enforce for a prolonged period. So that means that even though there may be a rule, and everybody may even know that it's a rule, if it isn't enforced, the company can't arbitrarily one day decide to enforce it. So in other words, if everybody on a certain shift shows up 5 to 10 minutes late every single day, and no one says anything about it and there's no discipline, they can't just all of a sudden on Tuesday decide that they're going to discipline you for coming in 5 minutes late. Now, the mistake that people make sometimes is thinking that prior enforcement somehow wipes the slate clean and that the company, the rules are no longer valid. And that's not the case. Just because the company has not enforced that rule doesn't mean they can't reset by informing all the employees that the rule is in effect and that there will be discipline. So they may not have disciplined you for wearing the wrong footwear for the last 6 months, but if they let you know in advance, come next Monday, everybody needs to be in the right footwear or they're going to face discipline, that's a reset. And now you no longer have that prior enforcement argument.
So the third one is due process. What is that?
Due process is sort of the most legal esque part of this. It's very similar to what you would see in law or court of law. A little looser. It's not the standards that we all think of. Proof beyond a reasonable doubt necessarily, but it requires that the employer has to conduct an interview or hearing before they issue discipline, must take action promptly, and once assessed, discipline may not be increased. So that's three separate things there. So the first one, they can't say to you, listen, we need to bring you in the office. We're going to give you a warning letter, and then start interviewing you, asking you questions, and then say, well, you're getting a warning letter because you just said blah, 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 blah. That means they determined the punishment before they investigated the crime, and that's not okay. The second part is they have to take action promptly. So they can't do their investigation 2 months after the incident happened, or do their investigation and put off the discipline discussion, for 2 months or whatever, and sort of leave you in limbo or hanging over your head. They have to follow a reasonable timeline of this is the incident, it was discovered, it was investigated, it was disciplined. And then the third part, which is a big one, is that once assessed, the discipline can't be increased. So in other words, if they say to you, you did X yesterday, we're going to give you a warning letter, you say that's nonsense, I didn't do this, that's garbage, and get angry, and they turn around and say, fine, then we're going to terminate you, which I've had happen many, many times. That is not okay. You can't just up the discipline because you feel like it, right? Whatever you said the discipline was going to be, that's what the discipline is.
All right. And then we got the fourth one, which is substantial evidence. What is that?
So that's pretty self-explanatory. It means that the charges must be proven by substantial and credible evidence. They can't just say, we were told by someone else that you did this, or we heard a rumor that you're, going 5 miles off your route for lunch every day. They have to prove those things. Now, that can be very quick and easy proof. If they have you on video, ripping open a package, taking the contents and putting them in your pocket, there's not much more they have to prove to that. A lot of these things, and I probably should have mentioned it a little earlier, but there are rules that we're all supposed to know by default, right? So you can't say, I didn't know there was a rule against stealing, or you can't say, I didn't know there was a rule against fighting in the workplace, right? Those things like that are expected to be common knowledge to be not okay, you're not going to win with just cause. If you get in a fight and you're terminated for fighting, you can't say, well, I didn't know there was a rule against fighting. So a lot of these things, you have to understand that you're not going to get away with murder, right? It's to protect you. It's not there to, give you carte blanche to do what you want.
And then the fifth one is equal treatment. What is that?
So equal treatment is to make sure that everybody is treated the same and fairly. So if I'm late to work and you're late to work, and we do not have prior discipline for being late to work, they can't say, well, David Allen's really handsome, I'm going to give him a warning letter, and we all know Greg Kerwood's terrible, so we're going to give him a suspension. Everybody has to be treated the same for the same offense, assuming there's no prior discipline. Now, if I already have a warning letter and you don't, that's a different ballgame. Now I'm going on progressive discipline for the same offense. But in general, they can't, they have to treat everybody equally. That's the purpose of that.
And then we got the sixth one, which is progressive discipline. What is that?
So that means unless something is, again, obviously what they say, what they would call egregious in sort of legalese, meaning, stealing, fighting, lighting the building on fire, things that are just obviously completely uncalled for and not allowed. There has to be at least one step in the discipline process where they allow you to correct the behavior. So in other words, if you show up late to work, they can't say, you're late today, that's it, you're fired, right? They have to give you a warning letter or a verbal warning or something that says to you, listen, this is incorrect, it's not okay, it's a violation of company rules, we need you to change that behavior. And then beyond that, if you fail to change the behavior, that's a different ballgame. But you have to be given an opportunity to fix whatever it is you're doing wrong going forward before they can start throwing out the big guns of discipline.
And then we got the seventh one, the final one, mitigating and extenuating circumstances. What is that?
So that is kind of catch-all for an arbitrator that sort of leaves the door open for them to take into account anything that may have caused the behavior in the first place. So in other words, say you're a driver, you've got a clean record for years, and then all of a sudden on Thursday, you go off your route and you drive to your home for an hour and a half. And they find out, they terminate you for it. And it turns out that, you got a phone call from your spouse that your child was having a seizure or whatever it is, and you rushed home. You clearly violated company rules by going off your route and going home and everything else. But there were extenuating and mitigating circumstances. You didn't just up and decide to do that to go, buy a scratch ticket at your favorite store. You went home because you thought there was a family emergency and you needed to be there. And it was more important to go immediately and not, take the time to notify your supervisor or get permission or whatever it was, right? So it doesn't just eliminate the behavior. The behavior itself is still obviously a violation and worth being disciplined possibly, but that extenuating circumstance can allow the arbitrator to say, all right, but we're all human here. I understand, this is an exception to that rule. This isn't worthy of a termination.
And with us covering all this, is there any kind of like final thoughts you want to loop all this back into one?
Yeah, I think the most important thing for people to understand is that the 7 tests of just cause are at the arbitration level, and then they sort of trickle backwards from there, because everyone knows that the final destination of anything that we fight will be arbitration eventually. So when you're at the panel or you're at a local level hearing, the labor manager and your business agent should have in the back of their mind what an arbitrator is going to do in any given situation. And these 7 tests of just cause are not there to give you permission to do things you shouldn't do. And I'm certainly not giving you permission to do things you shouldn't do. What those rules are there for is to protect you from egregious behavior on the part of the company, something that's outside the bounds, from them picking on you or harassing you or arbitrarily enforcing rules or playing favorites, is to ensure that everybody gets treated fairly when they make a mistake. We all make mistakes. We've all been there. We're all human. And what we want to do is ensure that they're not saying, we don't like this person, their mistake, they go. We like this person, their mistake, they stay. We want everybody to be treated equally and fairly and have an opportunity to fix whatever mistakes they may make, again, assuming they're not so egregious that it's immediate termination.